Doria Ragland has been arrested, Meghan Markle's mother, taken into federal custody at her Los Angeles home, and the charges filed against her are not minor. We are talking about a $35 million money laundering operation that federal prosecutors say was deliberately constructed, systematically operated, and directly tied to funds flowing out of the Archwell Foundation. This is not a rumor. This is not speculation dressed up as breaking news. Federal agents executed this arrest on January 30th, 2025, and what they uncovered in the process has fundamentally changed the legal landscape for the entire Sussex family. Because here is what most people do not yet understand. This arrest is not just about Doria Ragland. It is about what she allegedly built, who she allegedly built it for, and what that infrastructure reveals about how money moved inside the Sussex financial universe for years. When you follow the charges all the way through, what emerges is a picture of a family operation where charitable donations intended for vulnerable communities were allegedly funneled through a network of shell companies, fake nonprofits, and offshore accounts, and where Doria Ragland was not a bystander. According to prosecutors, she was the architect. Tonight we are going to walk through every layer of this, the charges, the evidence, the timeline, what this means legally for Harry and Meghan, and where this case is realistically headed. Stay with us, because this story moves fast and the details matter enormously. Let's start with the charges themselves, because they deserve to be stated clearly before anything else. Doria Ragland has been charged with 3 federal offenses: conspiracy to commit money laundering, structuring financial transactions to avoid federal reporting requirements, and operating an unlicensed money services business that prosecutors allege processed over $35 million in fraudulent proceeds connected to the Archwell Foundation scandal. Each of these charges carries significant federal sentencing exposure on its own. Together, they represent some of the most serious financial crime allegations in the federal criminal code. Money laundering conspiracy alone carries up to 20 years per count. Structuring violations carry up to 10 years per incident. Operating an unlicensed money services business adds another 5 years per violation. And critically, Ragland is facing multiple counts across all 3 categories. The theoretical combined sentencing exposure runs well past 100 years. What makes these charges particularly notable is that they were not filed hastily. Federal prosecutors are famously deliberate. They do not arrest someone of Ragland's profile, the mother of a globally recognized public figure, without a case they are confident will hold up to intense legal and media scrutiny. The decision to arrest rather than simply investigate further signals that prosecutors believe their evidence is not just sufficient but overwhelming. That distinction matters enormously when you are trying to understand how serious this moment actually is. Now, before we go any further into how federal investigators got here, I want to pause for a moment, because what we are covering tonight is genuinely significant. If you have been following the Archwell Foundation story and want to stay ahead of every development as this case unfolds, this is the channel for it. Subscribe and turn on notifications right now. Every update, every new filing, every legal development, we cover it here first, in full, with the detail it deserves. Drop a comment below and tell us what you think about tonight's charges. Does this change how you see the broader Sussex story? We want to hear from you. Now back to the evidence. The federal investigation into Doria Ragland did not begin with her. It began with the money. Forensic accountants working inside the Treasury Department's Financial Crimes Enforcement Network, FinCEN, were already deep inside Archwell Foundation's financial records in November 2024 when they began noticing patterns that did not fit normal nonprofit accounting. Payments were moving outward through what appeared to be legitimate consulting arrangements, service providers with professional-sounding names, contracts that looked clean on the surface. But when investigators began tracing where those payments actually went, the picture that emerged was something entirely different. The payments were flowing to a network of entities that, upon closer examination, had no operations, no staff, no deliverables, and no clients other than Archwell Foundation itself. They were not consulting firms, they were financial pipelines, and the accounts receiving those funds were ultimately tracing back to Doria Ragland. Between March 2021 and September 2024, federal investigators documented over $1.8 million in payments from Archwell Foundation to Ragland, classified internally as consulting fees for community outreach and program development. When agents examined what community outreach had actually been conducted, they found almost nothing. no documented programs, no verifiable community activities. Nothing that could justify ongoing monthly payments of $15,000 escalating to $47,000 to someone with no professional background in nonprofit management or humanitarian programming. That gap between the payments and the work, or more precisely, the complete absence of any work, is what elevated Ragland from a person of interest to the primary subject of a federal money laundering investigation. What the indictment alleges next is where this case takes on a level of organizational complexity that prosecutors say goes well beyond financial carelessness or poor record-keeping. According to the federal indictment, Ragland did not simply receive irregular payments. She allegedly constructed an entire financial infrastructure designed specifically to receive, process, and legitimize funds that prosecutors say originated from charitable donations misappropriated from Archwell Foundation. That infrastructure, according to prosecutors, consisted of at least 7 distinct business entities, each registered in different states, each carrying a professional name designed to survive surface-level scrutiny from banking compliance teams. Community Development Solutions LLC in Delaware, Global Outreach Consulting Inc. in Nevada, Humanitarian Services Group in Wyoming, Educational Support Systems in Montana. Each maintained a website, each had a registered address, each had documentation sufficient to open bank accounts and receive wire transfers without immediately triggering automated fraud detection systems. But investigators discovered that not one of these entities ever provided a single service to a single client outside of Archwell Foundation. They existed for one purpose: to receive money, move it through a layered series of transactions, and deliver it to accounts under Ragland's control, with its origins obscured. This is the definition of a money laundering operation under federal law. And the sophistication of its construction is precisely why prosecutors are charging conspiracy rather than treating this as an isolated incident. The indictment also alleges that Ragland was operating an unlicensed money services business. Federal law is unambiguous on this point. Anyone transmitting money on behalf of others above regulatory thresholds must be registered, licensed, and in compliance with anti-money laundering protocols. Ragland, according to prosecutors, transmitted over $35 million in funds through her network while operating entirely outside the regulatory framework. No licenses, no compliance procedures, no required transaction reporting. And the structuring allegations compound this further. Federal law requires banks to file currency transaction reports for cash transactions exceeding $10,000. It also makes it a federal crime to deliberately break large transactions into smaller amounts, specifically to avoid crossing that threshold. The indictment alleges Ragland did exactly this, repeatedly. In one documented instance, a transfer of $87,000 was allegedly broken into 9 separate payments of $9,000 to $600 each, processed through different entities on different calendar dates. Investigators documented over 200 instances of this pattern across the period under investigation. 200. That is not an oversight, that is a methodology. The timeline of how this allegedly developed matters, because it shows prosecutors building a case not around a single event, but around a pattern of escalating criminal activity that grew more sophisticated over time. March 2021. Archwell Foundation begins making monthly payments to Ragland. They start at $15,000. August 2021, payments increase to $35,000. The first shell companies are established. January 2022, a fake charitable entity is added to the network to expand laundering capacity as Sussex personal expenses, allegedly funded through Archwell, exceed $2 million annually. March 2022. Structuring activity begins, indicating a growing awareness of legal risk and a deliberate effort to evade detection. June 2022. Offshore banking relationships are established in the Cayman Islands. September 2022. Monthly payments reach $47,000. October 2022. FinCEN automated surveillance systems begin flagging the transaction patterns. May 2023. Federal compliance teams confirm that Ragland's companies provide no legitimate services, triggering formal criminal investigation. August 2023. Court-authorized comprehensive financial analysis reveals the full network. November 2023. Federal prosecutors determine charges are warranted. January 30th, 2025. Doria Ragland is arrested at her Los Angeles residence. That is nearly 4 years of documented escalation. A steady upward trajectory in both the volume of money moving through the network and the sophistication of the concealment methods being used. Prosecutors will argue that trajectory is itself evidence of criminal intent, and it is a compelling argument. Consider what that timeline actually represents in human terms. For nearly 4 years, while the Sussex brand was generating headlines about humanitarian causes, mental health advocacy, and charitable missions, prosecutors allege that a parallel financial operation was running quietly underneath all of it. Every public appearance, every foundation announcement, every charitable campaign, all of it allegedly occurring simultaneously with the systematic movement of millions of dollars through a network specifically designed to make those funds untraceable. That contrast between the public narrative and what prosecutors say was happening privately is something a jury will not be able to ignore. We are at the midpoint of tonight's breakdown, and I want to take a moment to note something. The reason we go this deep into the legal structure and the financial mechanics rather than just covering the headline is because the headline alone does not tell you what is actually happening or what comes next. If you find this level of detail useful and you want that same depth every time a major development breaks in this story, make sure you are subscribed. Hit the like button on this video and share it with someone who has been following the Sussex story, because the next few months are going to move quickly and the details are going to matter. Now, let's talk about what this arrest actually means for Harry and Meghan. Federal money laundering cases are built on documentary evidence. Bank records, wire transfer logs, business formation documents, transaction histories. This type of evidence does not fade. It does not contradict itself under cross-examination. It does not depend on witness credibility. It simply shows what happened, when, and in what sequence. 3 federal criminal defense attorneys with combined decades of experience in financial crime cases reviewed the allegations publicly available from this indictment. The consensus they offered was stark. The establishment of multiple shell companies across multiple states, combined with offshore banking and systematic transaction structuring, creates a documentary record that is extraordinarily difficult to defend against. The sophistication of the operation eliminates any argument based on negligence or misunderstanding. What the indictment describes, if the evidence supports it, is premeditated, structured, and sustained criminal activity. Federal money laundering prosecutions carry conviction rates exceeding 95%. The sentencing guidelines for cases involving this level of organizational complexity and this volume of funds place recommended sentences firmly at the higher end of the applicable ranges. Without cooperation, the realistic sentencing exposure for Ragland runs between 15 and 25 years in federal prison. That number is not rhetorical, it is the actual range prosecutors and defense attorneys are working within right now. And it creates a very specific kind of pressure on every person connected to this case. Because here is where the legal dynamics get genuinely complex. Money laundering cases are almost never just about the person laundering the money. The entire prosecutorial logic of a money laundering charge is that somewhere upstream there is a predicate crime, the original criminal activity that generated the proceeds being laundered. In this case, prosecutors have identified that predicate crime as the alleged misappropriation of charitable donations from Archwell Foundation. That means Ragland's case and whatever charges Harry and Meghan may face are not parallel stories. They are the same story told from different vantage points. And the person with the most detailed, most intimate knowledge of how money actually moved between those two stories is Doria Ragland herself. Federal prosecutors understand this, defense attorneys understand this. And everyone connected to this case understands that Ragland's decision about whether to cooperate with the government is potentially the single most consequential variable in the entire legal proceeding. If Ragland cooperates, the government gains an inside witness with direct knowledge of family financial conversations, decision-making discussions, and the specific instructions she allegedly received about how to structure the concealment operation. That kind of testimony from a family member who was present at the table is extraordinarily difficult to overcome at trial. If Ragland does not cooperate, she faces the full weight of the federal sentencing guidelines, with no cooperation credit, no acceptance of responsibility reduction, and no goodwill from prosecutors. The mathematical reality of that outcome is what makes cooperation the likely path forward. Sources familiar with the defense dynamics report that Ragland's attorneys opened communication with federal prosecutors almost immediately following the arrest. The cooperation framework being discussed would involve Raglan pleading guilty to reduced charges and providing testimony against the broader conspiracy in exchange for a recommended sentence in the range of 5 to 8 years, rather than the 15 to 25 she faces without cooperation. Federal prosecutors are described as very interested in what Raglan knows, because what she can offer is not just corroborating financial data. It is the human dimension of the case, the conversations, the planning discussions, the moments where intent was expressed that transforms a financial paper trail into a complete criminal narrative. And here is something worth sitting with. If Raglan does cooperate and takes the stand against her own daughter, it will not just be legally devastating for Meghan. It will be one of the most publicly visible examples of a family fracturing under federal pressure that this country has seen in years. The dynamic of a mother testifying against a daughter in a federal courtroom with the entire world watching is not something that can be managed through media strategy or carefully worded statements. It is irreversible. And the fact that prosecutors are reportedly prepared to offer Raglan a cooperation deal suggests they believe her testimony is not just useful, they believe it is essential. Harry and Meghan's legal teams are navigating this in real time, and the pressure being applied is significant. Harry reportedly had limited direct involvement in establishing or operating the money laundering network itself, but federal conspiracy law does not require direct participation in every criminal act within a conspiracy. It requires knowledge that a conspiracy existed and voluntary association with its objectives. If Raglan's cooperation provides evidence that Harry was aware of how funds were being concealed and benefited from that concealment, his exposure within the conspiracy could be substantial, regardless of his operational distance from the shell company network. Meghan's position is structurally more complex. As the primary connection between Archewell Foundation's operations and Raglan's financial network, and as the person from whom Raglan was allegedly taking direction on the concealment structure, Meghan faces the realistic possibility that her own mother's testimony becomes the government's central evidence against her. The scenario being discussed within legal circles that Meghan might consider approaching prosecutors with her own cooperation offer before Raglan's agreement is finalized reflects exactly how adversarial federal prosecutions can become when family members face overlapping charges. Federal prosecutors are skilled at using this dynamic. The first person to cooperate credibly typically gets the best terms. Everyone who waits gets worse ones. Let's be direct about what this arrest represents at a structural level, because it matters beyond the individuals involved. The Archewell Foundation, if the allegations in the indictment are accurate, was not simply mismanaged. It was allegedly used as the upstream source of a money laundering operation that ran for nearly 4 years, processed tens of millions of dollars, and involved the deliberate construction of a multi-state network of fictitious business entities designed specifically to defeat federal financial surveillance systems. The people who donated to that foundation, who gave money believing it would reach vulnerable communities, support humanitarian causes, and deliver on the charitable mission the Sussex brand publicly championed, are the actual victims in this case, not in an abstract sense. In the specific legal sense that prosecutors are required to quantify and present to a jury, real donations, real misappropriation, real people who gave money to causes that allegedly never received it. That is the moral and legal core of why this case carries the weight it does, and it is why federal prosecutors are treating it as a priority. As we close tonight, the situation is this. Doria Ragland is in federal custody facing charges that carry decades of potential prison time. The evidence, as presented in the indictment, is documentary, extensive, and built on 4 years of financial records that investigators have had time to analyze thoroughly. Her cooperation decision and the timeline of that decision will directly shape what happens to every other member of the Sussex family facing related exposure. The legal reality is that federal money laundering prosecutions do not typically result in acquittals when the documentary evidence is this comprehensive. The question is not whether Ragland will face consequences. The question is what cooperation she provides, what that cooperation unlocks for prosecutors, and how Harry and Meghan respond to a situation where the person who knows the most is now facing the strongest incentive to tell the government everything. That is where this stands tonight. And this case is going to keep moving. If you want to stay with us through every development, every new filing, every cooperation update, every legal turn, subscribe right now and hit that notification bell. This channel stays on this story until there is a final resolution, and based on where the evidence is pointing, that resolution is going to be significant. Leave a comment below. Tell us which scenario you think is most likely: cooperation, plea deal, or trial. The conversation in the comments on these videos has been sharp, and we read every one. We will see you in the next episode.